So I'm delighted to be here and to thank the NDA for inviting me. Just to say, basically, and I know time is limited, but what I hope to cover is a little bit of the background to the project, the analysis of the criminal law, which is Section 5 of the Sexual Offences Act of 1993, look at capacity and the functional test, both on the civil law side and on the criminal law side, and then look at capacity to consent to sexual relations, look at some offences or possible offences, defences then, and some other provisional recommendations that the Commission will be looking at, and I may not achieve all of that. I thought it was useful just to go back and say what happened pre-1993, and the Commission did a report in 1990 on this issue, which led actually to the 1993 Act, but unfortunately a lot of the Commission's recommendations weren't taken into account in the 1993 Act. But first of all, we had the Criminal Law Amendment Act of 1935. Just the years there each side are the years of imprisonment of people committed an offence. So just to say that Section 4 of the 1935 Act provided that any person who in circumstances which do not amount to rape unlawfully or carnally knows or attempts to have unlawful carnal knowledge of any woman or girl who is an idiot or an imbecile or is feeble-minded shall, if circumstances prove that such person knew at the time of such knowledge or attempt that such woman or girl was then an idiot, an imbecile or feeble-minded, shall be guilty of a misdemeanour and shall be liable on conviction thereof to imprisonment for any term not exceeding 2 years. Now, as you know, over many years, there is that whole offensive language and terminology. And what the Commission was saying was it was outdated at offences. And of course, the whole issue was that it only provided protection for females and not males. Further, then, we had the Mental Treatment Act of 1945, which actually provided for an offence for people in a position of trust or authority. And again, there was an imprisonment of 5 years. So it was very much a paternalistic and gender approach of the 20th century, and the whole question of people with intellectual disability, regardless of their capacity to consent, were effectively, if people had sexual relations with them or carnal knowledge or whatever, of a girl, I emphasise, that was an offence. So what the 1999 report did was try and strike a balance between protecting persons with intellectual disability from sexual exploitation, while at the same time respecting the right of such persons to sexual fulfilment. So if we move on then to the 1993 Act, effectively I've broken that down into 5 elements, and this is very much a cursory move through the Section 5 itself. First of all, it provides for 3 offences. A person who has or attempts to have sexual intercourse with a person who is mentally impaired, a person who commits or attempts to commit an act of buggery with a person who is mentally impaired, and a male person who commits or attempts to commit an act of gross indecency with another male person who is mentally impaired shall be guilty of an offence. And then there's the definition of mentally impaired. And again, the language is, as you see, we've moved on for that. Even if you look at the Commission's own report of 1990, it was using terminology of mentally handicapped, and of course we've moved on from that. But the definition of mentally impaired means person suffering a disorder of the mind, whether through mental handicap or mental illness, which is of such a nature or degree as to render a person incapable of living an independent life or of guarding against serious exploitation. So of course the whole issue of whether a person can live an independent life or whatever has nothing got to do with the issue of the understanding of the whole issue of consent to have sexual relationships. The penalties then were 10 years for the commission of the act itself of sexual intercourse. And of course what the 1993 Act did was to actually has been very much in the news in the presidential election, was to allow homosexual acts between consenting males. Up to that, of course, whether homosexual acts were either consensual or non-consensual, were of course a crime. So we had a balance, if you like, of the gender issue there, and then we have attempt 3 to 5 years, and gross indecency 2 years. However, two defences also in that act, that if a person in marriage, it was a defence if the sexual relationship with or without the consent, and also if the accused did not know or had no reason to believe, and I'll come back to some of those issues. It also provided, of course, that proceedings could only be taken with the consent of the DPP. And of course the statistics are very scarce on this whole issue of how many people, for example, with intellectual disability have been charged, etc., with an offence, or people who hadn't an intellectual disability who had sexual intercourse with a person with an intellectual disability. And we have a little study that was done by the Policy Office of the DPP's office recently, which isn't very conclusive, but the data is very scarce. Now, what the 1993 Act did was, of course, to create a new offence for people who are mentally impaired outside the marriage context. There's no provision for consent as a defence in situations where both people were capable of giving real consent to sexual intercourse. And of course then the fear of prosecution, of course, by carers, people in authority, etc., prevented and has prevented the development, and we've heard it in the last presentation, of education or the development of allowing relationships where there was consent and there was no element of exploitation. The whole question then of predicting the capacity to consent and the ability to live independently, of course, is not an accurate assumption at all, as a person is giving through consent or not. And it did not deal with the issue of sexual abuse or exploitation. Okay, in terms of the definition of mental impairment, it included a bit of exploitation there, but it did not deal with an offence of sexual exploitation or abuse. Just to say also, no reference to the offences in the Mental Treatment Act of 1945, which was interesting. Just to say on the Mental Treatment Act, of course, that was repealed in 2001 with the reform of the Mental Health Act, and of course now we're without that offence of person in authority. Now, just to say, of course, that in the 1990 report, and as a result of the 1993 Act provided that for, the Commission recommended the enactment of parallel offence in respect of anal penetration and other acts of sexual exploitation. But of course the Commission recommended that people with limited capacity or mental illness should not of itself constitute an offence, and this is really where the huge difficulty arises. The 1993 Act, of course, just to say very quickly that the common law has a functional test to capacity. In other words, that it's issue specific, time specific, and whether the person is consenting to the particular act. What the 1993 Act was brought in a status approach to capacity on the basis that if a person had an intellectual disability, they were automatically, regardless of the functional test and the ability to consent. Just to say, of course, people know that the Law Reform Commission has done quite a lot of work on the general issue of capacity and has recommended the functional approach in terms of the civil law, and that's very important. In that consultation paper of 2005, we raised the issue of the 1993 Act, and we got quite a number of submissions on both sides, both very extreme in terms of, on the one side, that complete ability to allow people to exercise their freedom to have sexual relationship, and on the other side, huge issues in relation, people wanted absolute protection for people with intellectual disability. So that's kind of where we're coming at. I'm just, again, relevant of the time, we all know the human rights and the rights-based analysis found in the UN Convention, the functional approach terribly important. And then I've just defined there the functional approach, what that means. It means the capacity with assistance if necessary to understand the nature and consequences of a decision within the context of available range of choices, and to communicate that decision with assistance as needed. Now, if we look at the criminal law then, on the other hand, and this has been an issue in other jurisdictions where there has been a divergence, if you like, between the civil law and the criminal law. In Ireland, the criminal law, again, has been based on the functional test, going way back 1845. I haven't time to go into the details of these cases, but very interesting. Second case there, 1886, was the case which set out the common law position of the functional test, which, if a person didn't have the ability to consent, then that would be an issue. So it established a subjective functional attest to capacity to consent to sexual relationship, and of course, as I say, those two 35 and 93 Act were based on the status approach. Currently, the common law presumption of capacity applies unless the issue is called into question. Of course, the issue of consent distinguishes between where a sexual activity becomes a criminal act or a protected right of the individual, and that's a very, very important issue. Obviously, on the one hand, we have on the civil law side the right of people to express themselves and have freedom to enter into sexual relationship. On the other side, we have abuse and exploitation of people who are vulnerable. A sexual offence, of course, concerning an adult can only be established where a lack of consent by the victim can be proved beyond reasonable doubt, and that gives rise to evidential issues, of course. Haven't time to go into the Australian case. I suppose England is the jurisdiction that has the most recent both criminal law and civil law on the issue of the functional test capacity, and again there were divergences in the UK between the civil and criminal law, and we have the Sexual Offences Act of 2003, which again went on the question of consent and functional approach, and we have, of course, the Mental Capacity Act. Now, there have been some very recent cases on these issues, and the discussion on the convergence of the criminal and civil law. I just say that MB case there, Lord Justice Mumby said there are policy reasons why criminal and civil law should in this respect be the same, that there was no forensic context that they should diverge in any way, and that's extremely important. The other case there, the reference might be a little bit incorrect, but Cooper, another issue arose in relation to a person who was sexually active, and there was an application made to the court to say that he didn't, the particular individual did not understand the issue or the consequences of the issue of him having sexual intercourse. And the application was to the Court of Protection to prevent him from having sexual intercourse. And there was evidence on both sides as to why not. The issue of education, sex education, came up before the court, and one of the expert witnesses said that if this particular individual did receive sex education, it would lead to anxiety and confusion. However, the court decided that post the 2005 Mental Capacity Act, it was terribly important that for a person to understand the consequences of the decision they made, that they had to be given assistance to and education, and the court demanded that before the court would make a final order preventing the relationship, that this particular individual should receive sex education. So it was a very enlightening decision, I thought, of the court, but very worthwhile. Now, the whole question of consent is not defined in any statute here. In England, they now have actually defined it in the 2003 Act, and it's actually freedom of choice, etc. Just to say again that in our rape legislation here, while there's no definition of consent, it does actually give an indication of where there's no consent, where it's intimidatory or coercive conduct or other threats which need not involve the threat of force. The whole issue then of lack of physical resistance or injury is not to be taken as free agreement, and that is reflected in the 2003 Act. And of course, a lot of the recent legislation, of course, does have protective offences. I know I'm galloping through this, and I don't know whether it's making sense or not, but I'm getting signals here, so I'm very much aware of that. So I suppose in drafting any legislation, one has to take into account the absolute right of people to, if they have the capacity to understand, to have freedom to enter into sexual relationships. However, a lot of research in other jurisdictions does indicate that people who are vulnerable are open to exploitation and abuse, and therefore the question on the criminal law side is whether one should have strict liability in certain circumstances. So in other words, the issue of a person in a position of trust or authority, whether there should be strict liability in those circumstances, even where there is consent to sexual relationship. There's also the question of whether a person, again, consenting, but actually whether the consent is actually real and free of any coercion, and that is another issue that the Commission is looking at. There are defences, as I say. Marriage in our 1993 Act is a defence. Again, in some of the Australian states, some of the American states, marriage is a defence. The Commission, just for what it's worth, does not feel, we in our Sexual Offences Rape Act said that you can now have rape within marriage, and we feel that should be reflected in our legislation. So marriage of itself, there should be free consent inside, outside the marriage, or whatever relationship is there. The question of reasonable, honest mistake, whether that should be a defence in circumstances. Again, you had cases in Australia where it was very much a subjective, but it could be a non-reasonable belief. And in England, they have introduced the reasonable objective mistake, although obviously subjected to the individual. So the issue of offences and defences is important. So what the Commission will be saying in its paper, which it hopes to publish in a week or so, is that consent to sexual relationships should reflect the functional attested capacity, and both on the civil and the criminal law side, the functional test should converge. That obviously, as a result of that, Section 5 of the Criminal Law Sexual Offences Act should be repealed, and we will be asking questions about a number of different protective offences, whether we should provide for those, and I think our view is yes, in certain circumstances. I suppose just before going on to those other issues is that the whole question of the definition of consent for the criminal law, again, is, as we know on the civil law side, we have the question of understanding the consequences. Looking at a number of jurisdictions, they really confine it to understanding the sexual act itself, but not understanding the consequences. England would be more ahead in the sense that it's understanding the consequences. In other words, the issue of sexually transmitted disease, or the issue that in a heterosexual relationship, whether pregnancy could result, and that's important as well. The Commission will be looking at and following through what it said in relation to capacity generally, and that is the issue of understanding the consequences, which I think is an extremely important point. Other issues that we just looked at was the question of reproductive freedom and the whole issue of parenting, etc. And really, as we all know, the NDA and the Rape Crisis Network have done very good work on that. Another issue is the whole question of criminal procedure and the whole question of capacity to give evidence of people with intellectual disability, and that is a big issue and a developing issue on, say, in relation to offences against children, but it's also an issue that needs scrutiny. So the fact, obviously an accused is entitled to a fair trial beyond reasonable doubt, and that is the threshold that has to be passed beyond reasonable doubt. But I think there are developing in other jurisdictions issues that could be accommodating of people with intellectual disability in that respect. So just to say, I'm sorry to be out of time and to have overspent my time. We're having a conference on the 7th of November in the Law Society on our consultation paper, and you're all very welcome to attend that. So apologies for the gallop through.